what a property or person is. And in fact, just as with status, there's sort of a continuum here as well. So that there are examples of things that are sort of a blend of the two. For example, corporations have rights. That they have legal rights that they can go to court to enforce. You can even go to court against a corporation. But at the same time, they're also property that can be bought and sold. So that they are a blend of the two. And it's not true that things necessarily have to, that this is a clean binary, that you're either purely property or purely person. There can be a blending of the two. And additionally, this is a reminder, property and personhood isn't the only way to think about animal status either. We'll talk about some cases in a moment here where animals were recognized, for example, as being victims of animal cruelty, which is a form of elevated status. It doesn't necessarily hinge on being a person or property, although they're closely related. Or laws that recognize, like such as the Animal Welfare Act, which say that animals in zoos or laboratories have to be protected with a certain standard of care. So that's sort of the high-level view of animal status, and just kind of get people thinking about it, what we actually mean by that. And so now this is the point where I'll pivot into going into a couple of specific examples. And to start with that, let's consider animal cruelty laws. Historically, just a couple hundred years ago, it was the rule that an owner could beat, torment, kill animals if the animal was their property, and there's nothing that anyone could do about it. And animal cruelty laws were first passed by Henry Berg, who founded the ASPCA in the mid-1850s, due to people in New York City being concerned about horses being overworked, being beaten in the public view, and in order to curb that, started passing animal cruelty laws. And now all 50 states have an animal cruelty law. This is like a very big generalization, but in general, animal cruelty laws say that you can't kill, injure, or inflict suffering on an animal unless you have a justification or an excuse for it, like self-defense, for example, or you just didn't look where you're going and accidentally stepped on a dog's tail would be excusable. Now there's a big asterisk there, and that's because animals aren't always actually protected, either by literally or by implementation. Cruelty statutes often won't apply to insects, for example. And I think there was a case recently where fish were determined not to be animals under the animal cruelty law. There's also exceptions for carving out a right to kill animals for meat and properly conducted research on them and so forth. So it's definitely not, this broad language has a lot of holes in it, but it is fairly broad, and it's very important because every state has a law like this. So just a question for you all, which is whether animal cruelty laws, which says that you cannot abuse and neglect animals in this unjustified way, whether those give animals legal rights. And that's important because, as I just mentioned a few slides ago, the definition of a legal person is, at least arguably, any entity that has legal rights. So the implication of animals themselves having rights under cruelty laws suggests that they might actually be legal persons. And I'm curious if anyone will proffer an argument either for or against the proposition that animal cruelty laws do give animals legal rights. No? Do you
It gives the state rights to prosecute, but the animal can't bring a lawsuit, so it's not, it doesn't have legal rights.
The state has to step in, and the state's not stepping in.
Yeah, that's a great answer. It's sort of it's the public interest, right? The prosecutor who's standing in the place of the state, they get to bring this animal cruelty lawsuits in the public interest, but it's really for public interest purposes, not for the animal's interests. There's other hands.
Well, it's also just saying that they can't be tortured. It's not giving them the right to, happiness, to freedom. It's just saying that you can't, abuse them and get caught. And since, like, they were saying they can't bring a lawsuit themselves, it's not necessarily a legal right because they don't have the choice in that situation. They're just knowing that it's illegal.
Right, so it's a protection, it's a limited protection, and it's not, and these laws aren't necessarily saying that a part of that protection is the ability to go to court to enforce it. Does anyone, before I move on, want to give a contrary view that they do have rights? Yeah.
I was just going to say, some people say that because animals can't have legal rights because they don't have legal duties. Therefore, if they don't have legal duties, they can't have legal rights.
Yeah, that's a good. So that's so the standard that I proffered is that a legal person has rights or legal rights or duties, but another view might be that you have to have both of them together, and that's actually a significant fault line in the legal discourse on this. Whether you also have to be capable of legal duties. The counter argument to that, which I find persuasive, is, well, first of all, humans. There are some classes of humans, like infants and severely disabled, who aren't capable of, that don't have duties, and second of all, if the whole idea is that the law, that legislatures or Congress aren't empowered to recognize these rights in the first place, my view is that they ought to be able to endow an entity with rights without necessarily having to give them duties. And so yeah, there are counter arguments that is an important fault line. So we'll put a pin in that question, and these next cases, which are specific applications and case studies on this question, will hopefully illuminate the discussion a bit more. The first case that I want to talk about is State v. Nix. This is an Oregon state case in 2013 that came from the Supreme Court of Oregon. And what happened here was somebody neglected 20 goats and horses. And they were charged with 20 counts of animal cruelty, one for each animal that they neglected. Now, the rule in Oregon and many other states is that one sort of course of conduct they can all be merged into a single crime. So if you were throwing rocks at somebody's windows and broke 3 windows, that could all be merged into one crime of destruction of property or something similar. However, you cannot merge them if there are multiple victims. So if you broke windows on 3 different houses, then each of the 3 victims there would be entitled to their own individual crime. And the question in Nix was whether they qualify as victims for purposes of this merger rule. And in what was really a landmark decision from the Oregon Supreme Court, they held that animals, in fact, are individual victims. And the reasoning was that animal cruelty laws, as they interpreted their state's animal cruelty law, wasn't just intended to protect the public from witnessing cruelty or protect the public morals. It wasn't intended just to protect owners from having their animals be cruelly treated, but was actually intended to protect the animals themselves from suffering. Oregon's animal cruelty law even recognizes that animals are sentient. And that being the case, each animal is a victim of animal cruelty, and the 20 counts of cruelty were left to stand. So,
sorry. Can you say a little more about what you just said? The Oregon animal cruelty law has recognized animals as sentient?
yeah, by statute. The statute itself says that they're sentient. And so just interpreting the statute, the Oregon Supreme Court, they determined that in enacting animal cruelty statute, or that the state actually was intending to protect the individual animals. They were the beneficiaries of the law rather than the public generally or the animal's owners, which was very important because going back, if a legal person is just any entity that has legal rights, and animals are the intended beneficiaries of an animal cruelty law, then in my view, the implication is obvious that animals themselves have legal rights under Oregon's animal cruelty law, and therefore are legal persons, at least with respect to those rights under the cruelty law. That's a question, yes?
Yeah, I have a question because I'm thinking in my brain right now that since it's so hard to get the sentencing more severe for crimes against animals, if you can get each act against a different animal as a separate crime, would with sentences with consecutive sentencing? So that, in essence,
Yes.
you're circumventing not being able to get more severe sentencing.
Yes, exactly. So in the case of the 20 counts of cruelty, that leaves open the possibility that those sentences might be served consecutively rather than concurrently, which is so that's very important on its own. And so when we're talking about status, the fact that animals are victims, that they're recognized as victims, is an important. It's a very significant court holding in terms of animal status generally, and then the question is whether there's an even bigger implication that animals therefore are considered legal persons in the state of Oregon. And so that's where the case of Justice the Horse comes in, which is one of the ones that, the case that I'm working on that Ashley had mentioned in my introduction. So Justice is a horse in the state of Oregon. He was neglected for 4 months in winter, left alone. He suffered frostbite on his penis. He was emaciated and starving. I think he was 300 pounds underweight. He had lice, he had rain rot. A neighbor complained, and the owner, Justice's owner, surrendered him to a horse sanctuary, Sound Equine Options, and the owner also pled guilty to animal neglect, paid some costs for his immediate care, but Justice has a requirement now for more lifelong care. He can never be left in an uninsulated or unheated shed for the rest of his life. He'll never be able to be exposed to cold temperatures again, and that costs like 4 times as much to house him as it would to house another horse. He needs socialization training. He requires medication and more veterinary care, and none of that's being paid for by his abuser. So we filed a lawsuit naming Justice himself as the plaintiff in the lawsuit. This was under a negligence theory, which is the same sort of lawsuit you would file if somebody was texting and driving and hit you with their car, and saying that this negligent activity from animal neglect caused him damages, and he has a right. He's entitled to those damages. The case was. Oh, he did recover, by the way, in this picture of him now. We're still fighting to have his costs of care paid for by the person who neglected him in the first place. His case was thrown out by the lower level trial court last year on the basis that he doesn't have the legal status or the legal standing to sue, even though if he did, all of the elements of a negligence case would easily be satisfied here. And so we've appealed, and our argument is I think, very, very simple and powerful, which is that Oregon's animal cruelty law benefits animals themselves, and because a legal person is anyone who has legal rights, that therefore Justice is a legal person, at least for purposes of enforcing his rights under the animal cruelty law. And doesn't necessarily go further than that, but that he at least has the right as a legal person to go to court to vindicate his rights under animal cruelty law. And so we just filed our opening appeal brief in that case a couple weeks ago, and it's the Oregon Court of Appeal and potentially the Oregon Supreme Court will sort this out in the months to come. I have one more case that I want to mention here, which is brought by the Non-Human Rights Project, which is another state law approach. This is Tommy the chimpanzee. He was and may still be living in isolation in the state of New York. And the Non-Human Rights Project is also engaged in state law litigation in state courts, addressing this question of whether animals are legal persons. Their approach is a little different from the Animal Legal Defense Fund, but it's a significant and important to know about. Their argument is that chimpanzees and other animals are cognitively and fundamentally the same as humans in all ways that are important in terms of being sentient, autonomous beings with a sense of self and so forth. And because, as an empirical matter, because they qualify as they are so similar to us, that they are therefore persons, and that as a person, each person has kind of fundamental rights, including the right not to be unlawfully imprisoned. And so they've been filing habeas corpus lawsuits to release Tommy and other animals. And although they haven't been successful in securing the release of an animal that way, that is another approach that is being taken to recognize animals as legal persons. So, my time is out, and I will cede the microphone to Danny at this time.
I'd like to introduce our next speaker. Danny Waltz is a staff attorney at the Animal Legal Defense Fund, who litigates against a variety of animal exploitation practices and industries. Danny lives here in Washington, D.C. with his wife, young daughter, and dog, and he spends his free time running around in neighborhood parks with all three of them. Give it up for Danny.
Thanks, Ashley. My presentation up. I am fired up about this room here. I think they're going to be really good Q&As sessions, so which I'm looking forward to learning. So to build upon what Chris said at the beginning of his presentation, I see the legal status of animals taking shape along the spectrum, from treating them as merely a form of property to giving full personhood rights equivalent to human rights. In my view, we advance further along the spectrum by giving value and legal protections to animals' subjective individual experiences and eliminating the ways that we think about them as objects. So I'm going to talk about two different approaches, categories of approaches, that animal advocates are taking to attempt to elevate the legal status of animals. The first is an approach undertaken in federal courts, unlike state courts that Chris was talking about. The approach is to identify federal laws that suggest subjecthood for a protected class, and then find a way to bring a lawsuit arguing that that class should be interpreted broadly, so broadly that the protections and the idea of subjecthood include both human and non-human animals. I realize that sounds pretty abstract, so I'm going to try to explain the approach through a few case examples, and all those examples are in actually a line of doctrine in the Ninth Circuit. The second approach animal advocates use to elevate the status of animals is by passing laws, and so I'll identify a few types of legislation that can provide avenues for moving the law's understanding of animals away from seeing them as objects and focusing on their subjective experiences worthy of protection. So 3 cases within the Ninth Circuit Court of Appeals demonstrate how animal advocates are trying to elevate status using litigation. The first is called Cetacean Community from 2004. In case you're wondering who cetaceans are, I didn't know this before I heard about this case when I first learned of it. These are 2 cetaceans, a resident killer whale on the right and a Dahl's porpoise on the left. In Cetacean Community, the sole plaintiffs were the cetaceans themselves. There weren't any human plaintiffs. They claimed that the U.S. Navy was violating the Endangered Species Act and other environmental laws by using low-frequency sonar during wartime and other quote-unquote active threat conditions. By bringing the lawsuit on behalf of the animals and the animals only, the lawyers forced the Ninth Circuit to consider 2 questions. First, does the U.S. Constitution prohibit animals from ever bringing a lawsuit in federal court, let alone say anything about the rights of animals? And second, even if the Constitution allows animals inside the courthouse doors, do any of the environmental laws allow the animals their statutory standing or the ability to bring a lawsuit under those laws? Amazingly, the Ninth Circuit first answered the question in favor of the animals, saying that it doesn't prohibit the cetaceans from filing a lawsuit in federal court. The language of Article 3 of the Constitution simply says that federal courts may hear a quote-unquote case or controversy. And the court noted that nothing in that text explicitly limits the ability to bring a claim in federal court to humans. The court looked at other entities like infants, cities, corporations, and even ships and said, hey, if the Constitution allows Congress the ability to authorize those things to bring a lawsuit, there's no reason why Congress cannot authorize animals to bring a lawsuit. This was and still is a very promising outcome. It says that our bedrock legal document does not necessarily exclude animals, and allows for at least the possibility that animals may themselves use a legal system to vindicate their rights and interests. But the victory was short-lived, and in fact, the court took it away just one page later in the opinion, saying that even though the Constitution allows Congress to authorize animals to bring suit, Congress had not provided them that authority in the Endangered Species Act and other environmental laws at issue. For example, the text of the Endangered Species Act says that any person may bring suit, and defines person in human terms, either individuals or collective humans like a corporation. In contrast, the definitions for threatened or endangered species who are protected under the Endangered Species Act use the word animals. And so the court said, looking at this structure of the law, it's clear that animals are the protected rather than the protectors in the Endangered Species Act. So they had no procedural right to bring the lawsuit on their own behalf. A human had to help. You may be familiar with how lawyers attempted to build off this cetacean community precedent in the Ninth Circuit. Several years later, creative lawyers at PETA brought a lawsuit on behalf of Naruto, the crested macaque, who took this selfie. Naruto alleged a claim under the Copyright Act. He argued that because he took the selfie himself, the humans who published a book containing his photograph infringed upon his ownership of the photograph. And it caused him economic harm. Yeah, if you like this, it's great. The judges, though, who decided the case were not happy with it. And they were also not happy with the cetacean community, the part of the cetacean community that said the Constitution may allow Congress to authorize animals to bring suit. But even though they were unhappy with this, it was a very unfavorable panel. They acknowledged that the cetacean community was the law of the circuit. And it actually even said that the difference between the types of injuries to the animals in the case, the physical injury from the sonar and cetacean community and the economic injury to Naruto, that didn't matter under the Constitution. Both are enough to at least get in the federal courthouse doors. So the fact that the judge is unhappy with the cetacean community could not change it shows the strength of the idea that the Constitution doesn't foreclose the ability of animals to vindicate their interests through lawsuit if Congress is okay with it. But just like cetacean community, Naruto was here tripped up by the statute under which he sued. And in fact, the Ninth Circuit judges made it harder now for an animal to demonstrate Congress has provided that authority. The opinion says Congress must, quote unquote, quote, plainly state that animals have the ability to bring a lawsuit. And they have to get express authority from Congress. Otherwise, they cannot file suit. For Naruto, this was a problem. The Copyright Act only allows persons, but that includes corporations to bring copyright infringement lawsuits. It doesn't say anything about animals. There's no express authorization. So for those counting, that's twice now where the Ninth Circuit has said, yeah, the Constitution doesn't have a problem with animals bringing lawsuits themselves, as long as the law under which they sue expressly authorizes it. So with those 2 points in mind, what would your next step be as an animal advocate? All right, write some laws that authorize it. Okay.
Constitutional amendment.
Constitutional amendment, that's courageous. Yeah.
Well, I think you have like several different avenues you need to pursue. One is to pursue implied powers as opposed to express powers, as one argument, and the other maybe would be we have to get rid of the word persons in the law to start with and change it to beings.
Gotcha.
Instead of everything being interpreted as persons, it becomes beings.
Yeah, okay, great. Good creative ideas. No shortage of them. That's great. Another approach is to do what Chris talked about, which is go to state court. Wouldn't be governed by the Ninth Circuit. Wouldn't have a requirement that Congress needs to expressly authorize bringing a lawsuit. Or maybe we could find a law that does expressly authorize it. It's hidden somewhere, right? You know, we're always discovering laws that Congress passed in the smoke-filled rooms. A different approach that we at ALDF are attempting still within the Ninth Circuit, is to kind of take a sidestep here. Instead of focusing on animals' procedural rights, and by that I mean using the legal process of bringing a lawsuit to vindicate his or her own rights, we look to federal lawsuits or federal statutes to see where we can expand substantive protections. So we're still using the favorable reasoning of citation community, just like the text of Article 3 of the Constitution was broad, case of controversy. If we can find substantive protections of a federal law that are broad enough to encompass humans and non-human animals, then those protections shouldn't just be limited, as they've traditionally been, to humans. Still, kind of abstract. So let me see if I can explain this using facts and the legal theory of our case. So here's a photo of Tony the tiger. He spent most of his life displayed for entertainment in a cage at a truck stop in Louisiana. We've had a long history of advocating to move him to sanctuary. In fact, won a state lawsuit, which was overturned by Louisiana legislature. In March 2017, we heard from a veterinarian that some recent photographs and videos she had observed that Tony showed him struggling to walk, and that suggested medical conditions threatening his health and even his life. Because Tony was in an exhibition, he was an exhibited animal, his living conditions were care were protected by the Animal Welfare Act, a law someone mentioned already, which is enforced by the U.S. Department of Agriculture. So we asked USDA to make a welfare check based off their veterinarian's concerns. And USDA did that, it made an inspection, but then told us to learn about the results of it, we had to submit a Freedom of Information request, a FOIA request. Which is, again, what we did. We were concerned, but because we were concerned that Tony was dying, we asked for them to speed up the answer to the request. It's called expedited processing under the FOIA. Here's the language of the Freedom of Information Act provision that allows for expedited processing. USDA denied our request to expedite processing records about Tony's health, and actually, before we ever got the records, because they weren't sped up, the cynics here can guess what happened. Tony died. In denying our request to speed up the process, USDA actually accepted that there might have been an imminent harm to Tony. But the agency said that the word individual, at the end here, only includes humans and doesn't encompass non-human animals. So naturally, we at Animal Legal Defense Fund did what we do, we sued. Looking for a show of hands. What do you think individual means? Does it include humans? No. Humans, yeah. Does individual include humans? Can I see hands? All right, most people agree. How about a collection of humans, like a city?
Individual cities.
What about an ant?
Yeah.
People like ant. How about a rock? Is the rock an individual? Yeah. I have a lot of individual rocks in my pet rock collection. What about a baseball card? Is that an individual?
Yeah.
All right. Cool. Here's what the dictionary says. This is the dictionary, one of the dictionaries, the second most common dictionary definition of individual. One could argue that if it does include objects like rocks, I'm going to come back to this, but here's the provision again. One could argue that if it does include objects like rocks, it's too broad. Someone could just ask the agency to expedite records for any construction project that breaks up rocks. So we argued that the right way to interpret this would be to qualify individual by the other words in the sentence. A rock cannot have an imminent threat to its life or physical safety because it's not alive. But think back to like the baseball card issue. Baseball card does have physical safety. Right? The collector keeps baseball card for safekeeping. They say, can you keep this safe? Kind of tricky line drawing issue. Still, even with the trickiness of that, we felt confident that the dictionary was on our side.
Yeah.
I mean, it even uses tiger as an example. As I said, as I was describing the case, the upshot of a win here would be that a federal court decision including animals in a class that receive substantive protections under federal law. So animals like Tony might not get a procedural right that they themselves can apply. Tony couldn't submit the FOIA request himself. But the law would view him as more of a subject whose life and physical safety have meaning and deserve federal agency protection. And then actually looking further down the road, a court interpretation that includes animals as individuals may pay dividends for those procedural rights, because we could then look to laws where Congress authorized an individual to bring a lawsuit. Yeah, I think you've been thinking about this already. You're like, that's where this is going. And say, whoa, this could be that clear statement of congressional authority for an animal to bring a lawsuit. But I'm getting ahead of myself for the case. We haven't won it yet. We're currently waiting on a decision. In June, we had an oral argument before a panel of 9 circuit judges. A couple of promising notes. One of the judges actually wrote Citation Community. And at an oral argument, another one of the judges on the panel said that it was abundantly clear that the word individual includes non-human animals. Right? End of the matter, we thought. Case closed. But it seems like the judges might, based off the questioning, add sort of something like an express authorization requirement from Neruda. They seem skeptical that Congress intended to include all animals within the meaning of individual. And that's several questions as to what Congress's intent was when it enacted the Freedom of Information Act. And so this is kind of a silly way of presenting how we responded at oral argument. We noted that, as the photo on the left shows, Tony was a tiger, and tiger is species protected by the Endangered Species Act, so his life and physical safety were protected by the Endangered Species Act. And also, as the photo on the right shows, Tony was an exhibited animal. And because he was exhibited, he was part of a class of animals protected by the Animal Welfare Act, whose life and physical safety are protected by the Animal Welfare Act. And since Congress enacted both of those laws, it had already deemed Tony's life and physical safety to be worthy of protection. So being consistent to say that under the FOIA, Congress intended to exclude Tony's life and physical safety from protection. You can watch the 9th Circuit oral argument. It's recorded on YouTube. All 9th Circuit oral arguments are, and on the court's website. And you can see what all the issues the court was grappling with. Actually, before I get to it. So someone had mentioned, actually everyone, a lot of people here had mentioned that a solution to the Neruda problem of there being no statutes in which Congress authorizes animals to sue on their own behalf would be to just pass laws that do that. I wish I could say that's a fantastic answer, and we've already done that. I'm not a legislative specialist, but my understanding is that passing a federal law granting animals the authority to sue could be a little challenging in this environment in 2019. But that said, there are a few types of state laws that I want to briefly introduce that could help chart a path for elevating animal status within the legal system. The first are laws that provide for an animal advocate to participate in animal cruelty prosecution cases. The first state to do this was Connecticut, enacting Desmond's Law. This law has been presented in the media as creating actually a role as an advocate to advocate for animal interests. That's not exactly what it did. It provided a separate advocate in the proceedings, distinct from the prosecutor and the defense attorney, who can present information that, quote, relates to the interests of justice, which is fairly vague. It's different than animals' interests. Connecticut may have landed on this law because the State Veterinary Association and the Kennel Club of Connecticut both strongly oppose this law and been a sort of middle ground. A Harvard Law Review article describing this by Neela Bala is her name. If she's here, I'm sorry if I mispronounced her name. I commented on this logo that I have here, pictured here, which was used to mobilize support for the law. And the logo and its focus on the link between human and animal violence shows that the law was at least motivated in part by viewing animals through an instrumental lens. And by instrumental, I mean that the animal's interests have value because the interests help advance and protect human interests. That said, Desmond's Law does provide for an independent advocate, and who would that independent advocate be there for, if not the animal victims? So in that sense, animals have gained an elevated procedural status in criminal court proceedings in Connecticut, which likely results in improved outcomes for the animal. I think it'd be really interesting study to see how the outcomes have shifted since those laws have been introduced. The second type of laws are state laws or municipal ordinances that achieve what citation community said was missing, an express granting of legal rights for non-humans to sue on their own behalf. I don't have an animal example, but the city of Toledo recently, through ballot referendum, enacted a Bill of Rights for Lake Erie. And those Bill of Rights instilled in the lake the right to flourish and be free from pollution, and also granted Lake Erie the authority to sue its abusers, polluters, in state court on its own behalf. Super interesting. That case, that's actually being challenged by the Farm Bureau, surprise, surprise, in federal court in Ohio. And finally, there are laws and ordinances that declare animals as sentient beings. Like the Tony the Tiger lawsuit, this category doesn't automatically provide procedural rights for animals, like the ability to sue if they vindicate their interests. It simply provides a more attentive view to animals as beings with subjective experiences, like the ability to feel pain or other emotions. And by giving those experiences value, the law begins to perceive animals as something more than property, and society begins to acknowledge them as deserving of more rights. The New Zealand Animal Welfare Amendment, quoted here, is a good example of this. So in the same amendment that acknowledged animals as being as sentient, the country also took steps towards banning the use of animals in cosmetic testing. So you'll start to see substantive protections come along with these sentience determination. All right, now that I've crammed your ears with a lot of stories about lawsuits and legislation, I am looking forward to thoughts and questions. Thank you.
All right, it's time for our question and answer session. If you have a question, please line up at the microphone in the center of the room. Try to keep your question concise and please indicate who it is for.
Okay, I have a question, and it's really for either one of you. It's fairly straightforward, I think. Is there an issue of frivolousness that people who are opposed to this kind of thing could introduce and say, for example, if a person has a case that goes to court, we hire a lawyer and we make a decision about who's going to represent us. But how does an animal decide who's going to represent them? And couldn't anyone just sue anybody on the basis of an animal or a group of animals?
Yeah, maybe we can go back and forth. But that question, I think, was raised in the Neruda decisions. In the Neruda decision, the judges really hammered PETA for acting as using what PETA called next friend standing, and there were several footnotes where the judges said PETA was just making how does PETA know what Neruda wants, and how can PETA say that by bringing this lawsuit and trying to craft some remedy, I think was money for sanctuary for President McCass? How can they say that's what Neruda wants, and is PETA really acting as a friend? So with certain judges, I think you're going to run into that type of reaction.
What did PETA say in response to that?
Oh, this was the opinion. I haven't read the press releases since then. Do you know how we went in a row? I didn't watch the roll.
Yeah, I don't actually remember it being a big part of it.
But I mean, I think the claims of frivolousness have been brought against the movement generally since the first animal advocacy lawsuits were brought. And I would imagine Mr. Berger, is that his name? And he started the New York's animal cruelty laws was probably thought of as the crazy person who had frivolous ideas. So, I think our organization thinks that animals, we're gonna have a position where animals are bringing their own lawsuits in 50 years. It's just a question of how we're going to get there.
I'll just quickly add that there are already procedures and laws on the books to deal with these situations for incapacitated adults and minors. And so we can look to those processes by analogy to apply the standard for determining who gets to represent the animal.
This could be for anybody. In the case of Tony the tiger, I don't know a lot about animal law, but why didn't the USDA inspector seize Tony when they found him to be an issue? And like I said, I don't know. This is maybe a stupid question.
Not a stupid question. Not a stupid question. Is there a USDA representative here who can answer this question?
I mean, law-wise, like, why?
So Chris actually is probably better positioned to answer this because Chris has read a lot of USDA inspection reports and is involved in lawsuits against the USDA for their attempt to create a blackout of FOIA responses about the inspections that they did.
Well, I think the short answer is that they actually have a lot of authority and they just refuse to use it. And in fact, I call this their fine and dash policy, where they basically they'll fine, or maybe they'll have an adverse inspection report, or they'll even have a proceeding where they revoke someone's license. But they very, very, very rarely actually try to seize the animals or account for their ultimate placement or disposition as a consequence for the violations of the Animal Welfare Act. I don't know why that is. I think it's crazy.
So it is something that they have the power to do.
Yes,
They
it is.
just don't do it.
Of course.
So this is another Tony the Tiger question. Just pushing a little further. So you sued just to get the information. And from what you just said, it sounds like the USDA has no obligation to release those welfare reports. Is that right? The inspection reports?
They do. They have the obligation to release them. They used to place them all up in what's called a public reading room, which is a website where you can click and look at the inspection reports. And they removed those. The Trump administration removed those for a while, which is what Chris lawsuit was about. But they do have the obligation if we submit a FOIA request.
So it depends upon the administration, though, as far as how much they do it. And then I guess the question is, why didn't you guys sue as opposed just to get the information? But once you did, for the fact that they didn't act, is there a lawsuit possible there? That they didn't act to save Tony?
Maybe.
I mean, there's a negligence argument in other cases.
I think the challenge would be mootness. It's hard to see what sort of relief you would get out of that by suing the federal agency that can't bring Tony back to life. So it will be one of the challenges. But
I guess it's to keep accountable.
it'd be hard to try to bring accountability to the question.
Anyway, I came a little bit late, so you may have already covered this, but could you talk about, in the history of our country, women and children were both property, African Americans were property, animals are property under the law. Is there any parallel reasoning to get this next class of individuals' legal rights?
Yeah, I mean, I think the question and the fact that historically we have been expanding sort of the protection of legal personhood is a indication of optimism. I think that we could be heading in a better place, and through some of these cases, even where they fail, there's a discussion and I think sympathies that are being generated that are tilling the ground for more fruits to be born in the future. So yeah, it's sort of, everything's a little different. It's hard to draw exact analogies, but the fact of the matter is, like, this is a legal system that over its 200 or 300 years of existence has expanded and changed in its understanding of what persons are and what rights are required to be given. And I think we're in the process of that happening right now with animals, definitely.
And advocates have attempted to use those experiences as sort of path to attempt. So, for example, you may be familiar with the PETA 13th Amendment lawsuit to get the orcas out of performing at SeaWorld, sort of putting them in slavery. And then also, I think our founder has maybe written a law review article about manumission, which was the ability of slaves to free themselves. Maybe that would be a path for animals as well. But the analogies also are there's a risk, especially like in the general public, of making analogies between animals and other classes of persons. That is something that animal advocates need to walk, and I'm sure there could be several panels about issues there.
Hi, I appreciate the work y'all are doing. In the case of Naruto, if the court said that who is PETA to try to interpret the intentions of Naruto regarding his copyright, his alleged copyright violation, couldn't PETA have said, kind of agreed with the court and said, yeah, in the case of Naruto and his copyrights, we may not have a good idea about what he wanted, but in terms of animals being abused and mistreated, clearly we know that the animals intend and prefer to not be abused and mistreated because we can interpret their behavior as showing that they don't like it.
Yeah, that's a good point. I think that would suggest, for bringing lawsuits to try to set precedent that concern animal cruelty, then maybe not economic harm, right? But this is something you've been grappling with in the justice case, right? As how to approach representing justice, right?
Well, in the justice case, I think it's a little more straightforward because the person who's his guardian in that case is the person who is the sound equine option. It's the sanctuary that actually took custody of him and has been caring for him and footing the bill for a lot of the problems that he's had to endure. So I think that's pretty straightforward, and I think it's where such as the case of PETA and Naruto, where there's not actually that kind of relationship, that organic relationship that already exists between the two. I think that's maybe where you start to run into problems.
Thanks to you both for your clarity and specificity in what you covered. Appreciate it. I was wondering if either of you have had any experience with the movement to increase the penalties for example, companion animal cruelty. I know in Ohio we had a movement to move the law from a misdemeanor to a felony. Have you, is that national, or have you had any experience with that?
Yeah, I'll take that. My home state of South Dakota actually was the 50th state a few years ago to add a felony provision to its cruelty statute. So all states now have a felony provision for at least the most egregious kinds of harms under certain circumstances to animals. But what's interesting is I actually see sort of the opposite happening now, where because of a lot of, I think, well-founded concerns about our criminal justice system in general, that legislatures and people are actually passing laws that have less penalties. So in California, for example, the law that says pet stores can't have to sell only shelter dogs. The law that prohibits the use of bull hooks in California. There's a law now that would ban sale of fur. Those are all only civil penalties, and they're not even going under the penal code with criminal provisions anymore. And I think a lot of that's due to the concern about over-incarceration and such.
Thank you.
Yeah.
Hi, thank you so much for your talk, and I really appreciate the work you guys are doing. So what's always on my mind too is in terms of the scope of suffering, I feel like farm animals are maybe the most oppressed group of animals in our society. And I know in the past couple of years, I think cat and dog meat was legalized, and there's always great steps taken for companion animals. Do you see this as gateway legislation, or sort of like the litigation legislation that you guys are doing? Do you see it as tying into future stuff that could help farm animals?
So that was, in our justice case, that was one of the concerns raised by the other side was, well, this is a slippery slope, right? You're gonna ban horse, if justice can sue over his abuse and be a legal person, then horse racing is gone, or eating animals in general is gone. Our response to that in the justice case was that we're just asking for animals to have the right to enforce, the ability to go to court to enforce the rights that they already have. So there's a certain modesty there, which I think makes justice's case more likely to succeed, but then the sort of the downside to it is, in that case, it's not actually going to illegalize these things. It's not actually going to create the slippery slope. The work for that is going to have to happen at the legislative level. Right? But with that said, to the extent that there is actual animal cruelty happening on farms, then these sorts of efforts could be used to stop that cruelty, right? If it's something illegal is happening, then this would be a procedural way to make sure that abuse stops. So there is a silver lining in it for farm animals, but it's definitely not like, there's not like some grand scheme where these approaches are necessarily going to like liberate the farm animals.
And on the legislative point, sure, I think that banning the cat and dog meat says something about our society, as well as California's ban on foie gras. Those could all be steps towards more farm animal protection. And shout out to the Humane Society, who seems to be working on very successful at the state level.
That's where we're going.
Oh, nice. Yeah. All right. Shout out to you for the state level work that you do in terms of California's recent success and farm animal protection, and Massachusetts recently.
Well, and actually, if I could add on to that, with like the Prop 12 and was it Prop 2 in California, these sorts of measures that say animals at least can't be in these tiny cages. There's a huge standing problem. If animal protection groups or concerned citizens think that animals are being illegally confined under that legislation, there ought to be some way. The animals themselves are the ones who are suffering as a result of that, and so they ought to have the status to go to court and make it stop. It can be when you have to sort of articulate it as a harm to a person, to a human or a corporation, it can be a lot harder to even get into the courtroom in the first place to make sure those types of laws are being enforced.
Thank you.
So we're out of time. If you do still have a question, definitely, yes, you should definitely follow up with Chris and Danny afterwards. I'm sure they'd be happy to talk about it outside in the hall. And that concludes our session. Let's thank our speakers.